Okay, good morning, everyone, and happy Cinco de Mayo. We welcome you to our next business success webinar. Today, we'll be talking about HR tips for the new normal. Today, we have a special presentation. We'll have an actual panel talking about this important topic and very timely topic, as well as things are starting to open up. Businesses are opening their doors again. So before we get started today, just a couple housekeeping rules. Please make sure to include your questions in the chat. I'll be monitoring those for any questions that we may get, and we'll reserve some time at the end to answer those questions for all of you. And then we are recording this presentation, so if you happen to miss any moment of it, you can refer back in our post-event email. You'll find that recording link along with our with the contact information for today's presenters. And with that, I'd like to go ahead and thank Isaac again, Javier and Marianne for presenting this very special presentation. And thank you all so much for being part of our success webinar today.
Sounds good. Thank you, Elizabeth, for the introduction. Buenos dias, everyone. My name is Isaac Hernandez. I'm going to be moderating the panel for us today, along with my two very experienced and esteemed colleagues, Javier Torres and Marian Zapata Rosa. Just a little intro for myself. I'm a 2004 graduate of U of A Law. Have been practicing labor and employment for the better part of 17 years. First half doing it management side for a couple of big law firms before going out on my own in 2012, representing now mostly employees with a sprinkle of employers, and happy to be a part of this seminar today. Javier is a 2010 graduate of UCLA, started off doing a little bit of IP work, but has been transitioning more into the employment arena and establishing his practice in this area for a while now, practicing in both California and Arizona. Marian has done something somewhat similar. She's a 2007 graduate of Howard University, same school that our current vice president went to. And she's currently with the law firm of Snell and Wilmer, also practicing almost exclusively, I believe, in the area of labor and employment, representing employees and employers throughout the country, focusing on Arizona and California. So with that introduction being said, I'm just going to lay out a brief outline for us in terms of what we're going to be covering. Again, the focus of our presentation today is to provide some guidance given sort of this new normal that employees and employers are dealing with. A lot of COVID related questions. Should I vaccine? Should I not vaccine? Can I require employees to vaccine? We'll be getting to some of those very common questions in the latter part of this presentation. We're going to be starting off with setting just some, covering some foundational issues, state and federal laws that come into play in dealing with our very common COVID questions. And we'll close up with some suggested best practices for you HR professionals or decision makers to keep in mind as you move forward through this process. And before we get started, just a little disclaimer. We are providing information on these issues. We're not providing actual legal advice. If you do have specific questions, some of those are going to require some follow-up. We'll kind of play it by ear depending on the questions that we get. We're going to try to cover some of the more common questions on our own to hopefully, address the questions that are out there among our audience. But we'll give you a chance to ask some questions, and we'll do our best to address them within the parameters that we need to be mindful of with respect to our professional and ethical obligations. With that being said, let's go ahead and get started here with the ADA, and I believe Javier is going to go ahead and cover this topic for us. Javier, go ahead and let me know when you need me to switch the slides. I'll try to pay attention as best as I can.
Hope you're on mute, Javier.
Classic. Thanks, Isaac. Thanks, Marian. And thanks to the Arizona Hispanic Chamber for having us. I'm very excited to be here with you all virtually. And happy Cinco de Mayo to everyone. Hopefully everyone has some nice margaritas lined up for later this afternoon. So I'm going to start talking about the ADA, the Americans with Disabilities Act. That is a law it's a general law that predates COVID, but it's extremely important right now in the era of COVID. And I'll explain why. So as you all know, there are lots of different laws that apply to employers, ADA, all the anti-discrimination laws, OSHA. A lot of the laws apply to different employers of different sizes. The ADA applies to employers with 15 or more employees. And it's important right now for two reasons in the era of COVID. It's an important law generally, but it's especially important right now because of two big reasons. First, the ADA prohibits discrimination against employees with disabilities, and it prevents the discrimination in terms of the hiring, firing, job advancement, job training, and just any terms of employment. And when we say that it prohibits discrimination against people with disabilities, what we mean in terms of this law is any physical or mental impairment that substantially limits or one or more major life activities of any individual. Basically, if someone has a disability, the ADA protects that employee from being treated differently by their employer. And the second reason that the ADA, so that's the first reason that it's important now in COVID, because it prohibits discrimination against employees with disabilities. The second reason that it's important in the age of COVID is because the ADA has special rules about asking employees about their medical information. And as we'll see in some of the examples that we'll talk about later, that comes up, in terms of vaccination, temperature checks, et cetera. So, the reason that you should care about following the ADA is because if employers don't comply with it, they can be subject to what's called administrative charges. Essentially, the employees can go to the government and file a complaint against the employer, which nobody wants, obviously. So Isaac, next slide, please. Thank you. So like I said in the last slide, the ADA prevents employers from discriminating against employees with disabilities. And so even though we're here to talk about COVID and its impact on your business and how you interact with your employees, it's important to keep in mind that the ADA protects employees with disabilities from discrimination all the time, not just during COVID. So the stuff we're going to talk about in these next slides, these are the general principles for the ADA, so they apply all the time, not just in terms of COVID. So one question that you might ask yourself is, well, how would I as an employer, discriminate against an employee with a disability? So the obvious question, or the obvious answer, the obvious way an employer can discriminate against someone with a disability is to just straight out treat them badly, because of the fact that, the employee is disabled, which obviously no one's going to do that here. So the less obvious way that this happens is and this is the meat of what the ADA does, is what if the employee's disability prevents them from doing all or part of the job, mostly if it prevents them from doing part of the job. So if that happens, what does the employer have to do in response to the fact that the employee is unable to perform part of the job because of their disability? So one quick example is, what if a cashier has lupus and has trouble standing all day at their check stand? What if a person's medical treatments, conflict with their normal work schedule? What if an employee's wheelchair doesn't fit under the desk in their office? So these are the kinds of things that you have to think about. That it's not about treating someone badly because they have the disability. It's whether their disability conflicts with the job. So under the ADA, the employer has to engage in what's called an interactive process to see if they can find a, quote, reasonable accommodation. That's the first bullet point, to see if they can find a reasonable accommodation for the employee so that the employee can continue doing their job even though they have the disability. So the first step in this process is the employer becomes aware of the disability in the first place. And that tends to happen in one of two ways. And first is if it's something that's visible or obvious to the employer. And if that's the case and the employer sees that the employee is having difficulty performing their job, the employer has to basically, be proactive and say, hey, what can I do to make the employee better able to perform his or her job? The second way that the employer might become aware of it is if the employee comes out and tells the employer hey, I have this condition, hey, I have this thing going on, can you please, help me, find a way to make my job easier to perform. If that happens, the employer can ask for verification, but it's not required to ask for verification. So that's what kicks off the interactive process, is the employer becomes aware of the disability. So once the employer is aware of it, the interactive process is essentially, it's an informal process, and the law actually says it should be an informal process. There's a ton of nuance to it, but essentially it's using a lot of common sense. It's using, being reasonable. That's the standard, is being reasonable. But really, I think it's also a good way to think of it as being kind. I'm an employer. I care about this employee. What can I do to make this employee that I know has this, physical disability or mental disability? What can I do to make this employee happy and able to fulfill their job? What would I want someone to do for me if I was in that position? So be reasonable, use common sense, and be kind. And so it's part of that interactive process. The law requires that if the employer can come up with a way to accommodate the employee without what's called undue hardship, without what's called direct threat, and without changing an essential function of the job, if there's a solution that doesn't require those three, or that doesn't require undue hardship, doesn't require direct threat to others, doesn't require changing the essential function of the job, the employer should implement that change to the job. And so those are those three bullet points. One is undue hardship. So if the employer can come up with a way that doesn't impose undue hardship on the company, they should make that change. What we mean by undue hardship is essentially like significant difficulty or expense as it relates to the business itself. And so it's essentially how much of if you can do this without a huge impact on your business. And it's a very, there's no bright line test for this, but essentially you look at the sizes and the resources of the employer. So a small mom and pop store is going to have less resources to make big changes versus a large, chain that has a lot of resources to make big changes. You look at how much the accommodation that the employee is asking would cost. Are they asking for a new chair, or are they asking for like entirely new building to be built just for them? So that's the kind of thing that you look at. The second thing that you look at is whether or not the accommodation that the employee is asking for would pose a direct threat to other employees, and that becomes important right now in the age of COVID. Is what they're asking for going to create a direct threat to other employees? An example is if you had an employee who operates heavy machinery and they have uncontrolled epileptic seizures, you would think, okay, that person probably can't perform that job given the fact that they have uncontrolled seizures without putting others or themselves at risk. So that's the kind of thing that you look at to determine whether or not the thing that the person is asking for is a reasonable, accommodation. And then the third thing you look at is if you're thinking about maybe like a person does a job that has 10 tasks, and one of those tasks the person's having trouble, performing, is that task something that is not what's like an essential part of their job? Like, is it something that they do kind of on the side? Is it something they do once in a while that you can take off of their job description, and so they can still perform, like the main part of the task of their job? So in the example above that I said about the cashier who has lupus and has trouble standing all day, the employer might say, okay, well, you have trouble standing all day, let's get you a stool. Does that work for you? That's the kind of thing you kind of go back and forth to see if the employee would be fine with that. Another example, if you have a cleaning crew, one of the people on the crew has a prosthetic leg, they're able to do all the cleaning generally, but they have trouble, cleaning the stairs. Then you think to yourself, okay, the main job is cleaning, the main floors. Let's have another employee, clean the stairs. So that way the employee with the prosthetic leg can focus on the main part of the job. A third example, and this is something that will come up in the era of COVID, is someone says, I need 6 weeks off, for back treatment. I need 2 weeks off for this condition. So generally, if the company provides for paid leave, you should let them use it. But if it doesn't, you have to ask yourself, does providing the employee the 6 weeks or whatever of unpaid leave, is that going to create like an undue hardship to the company. If it doesn't, then you should definitely consider providing that leave. So those are kind of the general principles here of the ADA. We have the employer becoming aware of the condition. We have the interactive process where you try and find, you know, a reasonable accommodation. And so later in the presentation, we'll apply these same basic principles to examples that we see in the COVID world. So now I'll hand it off to Marian, and she'll talk to you guys about the FMLA.
Yeah, one quick comment, Javier, before we finish off, just two points that, and this will come into play as we progress through the presentation. Sort of rules of thumb with respect to the ADA, I'm just going to chime in. An employer, this is sort of a bright line rule that have been recognized by the courts. Employers do not need to create a new position for that employee under the ADA. That's a bright line rule that's pretty widely accepted by the courts. Another sort of rule of thumb or guiding principle is that if you have done something in the past, if you've changed a function or job function in the past under different circumstances, that's going to tend to support an employee's claim that what you did in the past, you should do here, it's reasonable. And then just to finish off the final point on the slide before we move on, there is a no retaliation provision within the ADA. So if an employee tells you that they're sick or that they need help to accommodate either a perceived or an actual disability, they are protected under the law, so you cannot retaliate against that employee. With that being said, Marian, we'll move on to the FMLA. I hand it off to you.
Sure. Well, and I can add just a couple of thoughts about the ADA generally too. I think Javier did a really nice job of touching all the high points in the law, which it is not easy to do because there are certainly many ways that employers can find themselves in trouble under the ADA. But, you know, the takeaway for me kind of in broad brushstrokes is that what you don't want to be doing is asking employees if they're disabled, what their disability is, what you really care about. And if you look at this issue this way, you know, I think it's helpful. What you really care about as an employer is whether your employees are able to perform their essential job functions. Do they have any limitations or restrictions in performing the essential job functions, whatever the underlying condition may be? And if they do have a limitation in performing their essential job functions that's based on a disability, then, you know, you're required to try to find a way to work out an accommodation. And some conditions are more evident, physical ailments, individuals in a wheelchair, sometimes that's more obvious, but it's really, you know, the emotional, mental conditions, depression, anxiety, some of those other types of conditions that can be very difficult to recognize, difficult for employees themselves to come forward and report, and difficult to accommodate, you know, in the workplace because of, you know, kind of the havoc that they might be causing in the individual's life. And so this is a process. The best way I've ever heard the ADA described is it's getting on the dance floor with your employee and going through, you know, this process. The first person to leave the dance floor loses. So think about it that way. You know, this condition might change over time. They might improve. They might worsen. It's not a one and done. You know, you're in it to dance. And ultimately, you know, to help provide protections for your employees within what you're required to do. One other final comment about the ADA is, at least at the federal level, you also can't discriminate against employees if they are associated with somebody who's disabled. For example, they have a disabled child, disabled spouse, and so we may see, you know, more incidents coming up along those lines where somebody's loved one has an underlying condition that's exacerbated by COVID or the pandemic, and they're having to take more, you know, time off or needing, you know, other leniency around the workplace. At the federal level, there's no requirement to accommodate somebody who's associated with a disabled person, but certainly some states view that differently, California being one of them. And at the end of the day, you can't discriminate against an employee because they're associated with someone who would be disabled. So, you know, lots of really interesting issues that come out of the ADA. At the end of the day, if you have an employee come forward and request an accommodation and you don't know what to do with it, it's a good time to just pick up counsel before you make any knee-jerk decisions. in that space. So with those thoughts, I'm ready to talk about our next federal law, FMLA, and Javier and Isaac chime in if you have thoughts here. So the Family and Medical Leave Act of 1993 is the law that comes to mind when somebody needs to take time off related to pregnancy, adoption, bonding. You know, typically people will think of the FMLA in those situations, but really it's a law that covers more broadly than just those circumstances. It also covers certain types of military leaves, and it covers individual employees' serious health conditions, as well as serious health conditions of their family members, covered family members. So, so to begin with, employers should look at whether the FMLA even applies to them at the federal level. And it's a two-part test. The first part is looking at coverage for the employer, looking at whether the business is covered. And all businesses are covered if they have 50 or more employees working within a 75-mile radius. So you might have two different bakeries, 25 employees at each one, but they're within 75 miles of one another. So you would be covered, you would meet that 50 employee threshold under the FMLA and be covered as an employer. Just because you're a covered employer, however, doesn't mean that all of your employees are covered, because the second part of the test is whether the employee is covered. And in order for employees to be covered, they have to have worked 1,250 hours for you in a 12-month period. It doesn't have to be a consecutive 12-month period, but in a 12-month period. So for example, employees who've just started with you, even though you might be a covered employer under the FMLA that has to provide FMLA leave, that person that just started on day one, they're not eligible for FMLA. They have to work with you for 1,250 hours over the course of 12 months, non-consecutive. Next slide, Isaac. All right, and so what does it cover? We talked about how typically when you think of the FMLA, people think of, you know, pregnancy leave, and certainly that's the case. It is the sole federal law right now that applies to private employers for providing maternity leave, bonding leave, adoption leave, two types of military leave that are covered to care for covered service members, and also relating to qualifying exigent situations that are defined in the statute. There are about 16 of them currently that apply if you have a family member who is a covered member of the military. And so when you think about the FMLA, people think primarily about pregnancy or the medical leaves, but there are other reasons as well that are also covered. The one that is getting the most attention presently is the leave provided for a serious health condition. And not just anything is going to qualify as a serious health condition. We know anecdotally that colds, flus likely would not be recognized to be a serious health condition. A headache is not going to be a serious health condition under the FMLA. So what the definition is looking for is either a illness, injury that requires inpatient care, or an overnight stay, could be at a hospital or a medical facility, or illness or injury of more than 3 consecutive days of incapacity or treatment within 30 days. So if your employee is out incapacitated for 3 days or more, that should be a trigger, you know, that that you need to get the FMLA paperwork out and see if this individual wants to avail themselves of FMLA. But the definition of serious medical condition, it may or may not overlap, frankly, with cases of COVID. You know, one thing that's been incredibly interesting and difficult in the pandemic is the unknown with respect to how severe somebody's reaction could be to COVID-19. And so, you know, you've all, I'm sure, heard of cases of individuals who maybe tested positive, had a sniffle, were out for a few days and then bounced back. You know, we're on the other end of the spectrum. We know that others are, you know, severely sick and hospitalized for significant periods of time. And so with respect to the FMLA, recognizing that not every case of COVID or even flu, will qualify as a serious health condition, but certainly to the extent that it's causing employees to have overnight stay in hospital or medical facilities, or is lasting for more than 3 consecutive days of incapacity or treatment within a 30-day period. Also, chronic illnesses are certainly considered serious health conditions under the FMLA. All right, next slide. And so what does the FMLA provide? So if you figure out, okay, I'm a covered employer because I have 50 or more employees within a 75-mile radius, and this employee's been with me, longer than 12 months and also works more than 1,250 years. So I'm covered as a business. This employee is covered as an employee. They're asking to take medical leave for a serious health condition. Now, what am I supposed to do? One thing that I think, frankly, is helpful in managing the FMLA that doesn't exist with the ADA is that the FMLA provides certain forms. They're available to employers on the DOL's website. In fact, the DOL just updated those last year, but it provides certain forms that you can use and should use to administer the FMLA leave of absence request process. So there's a notice form that goes out initially. You provide employees about their notice of their rights and responsibilities. And then if it's medical related, there are certification forms that you give the employee and you tell them, I need this back within 14 days. Failure to return it within that time frame could lead to the leave being denied. Although generally, you want to provide some leniency, particularly if it's outside of employees' control. In the pandemic, we saw doctors' offices that couldn't get to forms. They couldn't get to FMLA forms, not within 14 days, maybe not at all. And so, there was just some practical aspects that needed to be applied over the course of the last year in administering this process. But the FMLA has those forms and it has that process. There are pretty strict time periods when all of those things generally should happen. And it's helpful because it provides a framework for which you can comply with this law. And so if the employee turns back their medical certification and you designate that they are eligible for the FMLA, that if they qualify, you're covered, they're covered, the condition is covered, it's a qualifying circumstance, then what they're entitled to is 12 work weeks of leave. And the big question is always whether that time is paid or unpaid. The FMLA, and we'll talk a little bit later about what came about under the CARES Act, but the FMLA is unpaid. It's an unpaid leave of absence. And so really what you're providing is the time off, but also the job protection at the end. And the employee doesn't have to take all 12 weeks. They can take 1 week. They can take, in certain circumstances, they can take 2 weeks now and maybe another 4 weeks later. That kind of accommodation is often the case with maternity leave, where a father will take an initial week when a baby's born. And then once the other spouse returns to work, maybe they'll take some additional time then, so separate the leave. But it's a total of 12 work weeks. And at the end, when they're ready to come back, what they're entitled to is job protection. And so what that means is that they have a right to come back and be put back into the same or substantially similar position in terms of pay and benefits and other aspects of employment. Now, the question becomes, what happens if I laid everybody off while that person was on leave? Do I have to bring them back? And there's the FMLA has extensive regulations, and there's one regulation in particular that we point to as employers to argue that an employee on leave is not entitled to any greater benefits than if they wouldn't have taken the leave. So if they would have never gone out, and if they would still be working at the bakery, and if they would be laid off just like everybody else, then they're not entitled to any greater treatment than what they would have otherwise received had they stayed with you the whole time. So the only other comment here about this job protection is that under the ADA, there seems to be guidance that suggests that employees have to come back to the exact same position that they previously held. So if you put somebody in as a temp, if you have somebody else covering it, when that employee is ready to come back, you've got to move those other individuals out of that role and give him or her the job back. Under the FMLA, it's sufficient to return them to a substantially similar position. And so if the job has been restructured, but you have something else that provides similar pay, similar benefits, similar duties, you might have more leeway there under the FMLA. All right, next slide, Isaac. Okay, so we talked a little bit about this concept called intermittent leave. And so the point here being that an employee, if they're entitled to FMLA, they don't have to take it all at once. They can break it up under certain circumstances. And frankly, this law received an overhaul not quite a decade ago. And one area where employers were really optimistic that they would get some clarity and some, help from the Department of Labor was with respect to intermittent leave that is for unforeseeable treatment. And DOL kind of fell flat on this, in my opinion. The DOL said that if an employee is going to take a leave of absence that is foreseeable, maybe they're going out for cancer treatment, maybe they're going out for scheduled surgery, something like that, that in those cases, you can move them to another position that would better accommodate that leave of absence. But what's frustrating from an employer perspective is that's not what's challenging, right? Generally speaking, if you have notice about somebody's need to take time off in the future, you can plan for it. You can work out your schedule. You can rearrange things so that that can be accommodated. Where it's really challenging is where you have individuals who are taking leave on an intermittent basis, and maybe they're calling the morning of and saying, I can't get out of bed, I'm depressed, I'm not coming in, this is an FMLA day. And so you have no notice, other than right before the shift starts, and you're struggling to find someone to fill in, or you're having managers come in to cover. And so that's an area where it would have been nice for the Department of Labor to have provided more clarity for employers and allowed those individuals to be moved to positions that better accommodate it. But if it's unforeseeable like that, if it's just intermittent leave that's not foreseeable, you can't move people. And then the other question here on this slide is, how does an employee accrue leave once it's exhausted? So FMLA runs on a 12-month period. As an employer, you can decide how you want to designate that. Are you going to run it on a calendar basis from January to December? Are you going to run it on your fiscal year? Are you going to run it on the employee's anniversary year? However you want to designate that 12-month period, you can decide. However, once you've decided, then that's the time period you need to use. So if the employee has exhausted their 12 work weeks of leave in that 12-month period, whether it's January to December, or however you've designated, then they're out of leave until they're able to earn or accrue leave outside of that 12-month period. So next slide. Isaac, unless you either Javier or Isaac, any comments about the FMLA?
But just chiming in here with a couple of highlight points. I believe, Marian or Javier, correct me if I'm wrong, but the FMLA also provides an exception for certain high-level employees. So if you're CEOs or C-suite officers, vice presidents, the FMLA would not apply. Is that right? That's kind of tickling the back of my head.
So what you're remembering is what's referred to as a key employee exception. And the company can designate individuals who, because of their position and compensation, their level of compensation, they're designated as key employees, without which your organization, would not effectively be able to operate. And so you can designate that you're a key employee, and so you're not entitled to these protections, but it really is limited to individuals kind of at the upper echelon of executive, administrative, and management. Yeah.
Right. So the other points I just wanted to share, at least from my perspective, doing a lot of plaintiffs' employment work, and how the FMLA is different than the ADA and some of our other, broadly broad anti-discrimination statutes. When we're dealing with anti-discrimination statutes, one of the difficult hurdles that we face representing employees is establishing motive, that there was some intent to discriminate. That's a pretty difficult hurdle to overcome as a plaintiff's employment attorney. The FMLA does not require motive. It is a hyper-technical federal law, and employers of all sizes, sophisticated employers, national companies have HR and supervisors and management that trip over these requirements all the time. So if someone says to you that they have a condition themselves, or they have a child or parent at home that they need to care for, the one point that I want to emphasize is that once you have that notice from an employee, and it does not have to be in writing, within 5 days, you have an obligation to provide the notice of FMLA rights that Marianne noticed earlier. That's really the first thing out the gate that you as an employer need to be mindful of. That's it. That's my comments on the FMLA. Anything further to add before we move on?
Sounds good.
All right, so we're moving on to the sick leave, and Marian, I'll just try to suggest that we try to keep this to 5-10 minutes so we can have some time to cover the questions, and then we open it up to the audience.
Okay, perfect. Let's get through this topic quickly. So as I'm sure most of you know, Arizona has a paid sick leave law. It took effect in July of 2017. And actually, I spoke at the Arizona Hispanic Chamber then when this law was brand new and talked about all of the nuances related to that law. But effectively, it provides paid sick time for all employees in the state. Regardless of whether they're part-time, full-time, temp, exempt, non-exempt, all employees are covered. And if you skip to the next slide, we can talk about quickly what some of the requirements are. So the paid sick time effectively can be used for medical care for a mental or physical illness, injury, or health condition for the employee and for the employee's family members, and that's defined. It can also be used for absences related to domestic violence or the need, to obtain protection relating to stalking or sexual assault, sexual abuse cases. So if an employee needs to take the time to go to court and get a protective order, that would be covered. And then finally, it provides time off for this third category that we mostly ignored until the pandemic hit, which is specifically for public health emergencies affecting the employee or their family member. And that was specifically defined as requiring the governor to declare a state of emergency. We now no longer are in a state of emergency in Arizona. But those are the main requirements. And in addition to that, employers have to put up their paid sick time poster. Most of the poster companies, although we don't know for certain if all of them do, but most of the poster companies, they've included it in their Arizona state posters. And then employers have to track the time off. So on the employee's pay stub or something submitted with the pay stub every pay period, they have to track how many hours they have available, how many hours they've used, and how much pay they've received, for the time taken off. And they have to maintain records appropriately. Failure to put up that poster, failure to track it, failure to give employees the required time off, all of those could, lead to some form of consequences with the Arizona Industrial Commission. Next slide. And so how much leave are you required to give employees? It depends on the size of business. If you have 15 or more employees, you're required to provide employees with at least 40 hours. If you have less than 15 employees, you're required to provide them with at least 24 hours a year. And you can do it in one of two ways. Sometimes the easy way to do it is just to say calendar January 1 of the first year, everybody gets a full 24 hours or full 40 hours. Once you use it, it's exhausted. Or you can have employees earn it as they go at a rate of 1 hour of paid sick time for every 30 hours worked. Either way is acceptable. Sometimes if you manage your own payroll, it's easier to just award it up front rather than have to track it each pay period and let employees exhaust it that way. Next slide, Isaac. All right, and what we've seen is that since, besides the FMLA, since there isn't any federal law that provides paid sick time off at a national level, we've seen states like Arizona and others all over the US start to have their own paid sick time laws in a really hodgepodge fashion. So if you have operations across multiple states, it's imperative that you're not only looking at the paid sick time in the state where you're headquartered, but in all of the other states where you have employees. For example, we know that Colorado and New Mexico are going to be added to this list January of 2022, with New Mexico providing up to 64 hours a year of paid sick time. So that's a huge allotment that's coming. And it's going to also provide that employees can receive overtime for that time off. So, these laws can vary so much state to state, and you just want to be mindful that you're complying in every state where you have employees and are covered. Next slide. All right, and then this slide, and I won't go into this so we can get to some of the more practical questions in this area, but this slide just provides what the risk is for failing to post, for failing to record, for failing to keep a hold of those records, I believe for at least 4 years, or failing to provide employees with the time off. You can have a complaint raised against you at the Arizona Industrial Commission. Employees can bring a private cause of action against you directly, for these types of violations. And what can be problematic here is that to the extent that you're failing to pay employee wages appropriately, you could face other types of damages like liquidated damages for failure to pay wages. So want to make sure that if you aren't complying or not fully comfortable with complying with the state paid sick time law, that you're up to speed. Certainly in 2017, we saw a lot of leniency from the director of the Industrial Commission. They were doing a lot of education. They were throwing employers lots of bones. That time has long passed. They're in enforcement mode for sure, and they have been for some time.
All right, so we've covered a lot of the substance. We had one other federal statute that we had in our PowerPoint for presenting today. What I'm going to suggest to my panelists is that we skip over the FFCRA so we can get to the COVID questions. And if we have a minute or two, and we may even be referring to it in our responses to the questions. So let's just skip to the questions for now.
Yeah. Isaac, let me just say this. With respect to the FFCRA, if we don't get to it, please know that it expired. So if you want to, on a voluntary basis, continue to let employees use it and continue to get tax credit for it, you can do that through September of 2021. But if you're not deciding to do that on a voluntary basis, it has expired. And so you're no longer required to do so.
Perfect. And for anybody that needs a little more context, we do have some slides in here that lay out basic requirements if you do want to participate in that voluntary program that's still in effect through when, Marian?
September of 2021.
Right. All right. So we have our first COVID Q&A question, and this is going to be fielded by Javier, and we'll chime in, Marian and I, if we have any further commentary. So Javier, can employers require employees to receive the COVID vaccine?
Yes. Okay, next question. Just kidding. All right, so yes, everything's always really complicated with lawyers, obviously, but usually for good reason. So the answer is yes, but here's a couple things to keep in mind. That ADA, remember at the beginning I said the ADA prohibits employers from asking questions about people's disabilities unless they're related to the job and necessary for the conduct of the employer's business. So let's keep that in mind. You can't ask questions about people's disability unless you basically need to. So so while you can require them to get a vaccine, the way you would verify that they did is you say, hey, did you get the vaccine? Yes or no. So that question in and of itself doesn't implicate one of those kind of like prohibited questions, because there's a lot of reasons why people can choose not to get the vaccine. For religious reasons, might be allergic, they might, out of just like general fear, out of politics. So just asking them, did you get the vaccine? They can say yes or no without you getting into, whether or not they, they have a disability. But if you ask the follow-up question, if they say, no, I didn't get the vaccine, and if you ask the follow-up question, why didn't you get the vaccine? That's scary, because they might say, oh, hey, by the way, boss, I'm disabled and blah, blah, blah. So that's when it gets really scary. So then if you feel that they need to have the vaccine to do the job, and they say no, you have to ask yourself, does having the vaccine implicate the safety of other employees? Like, is this person in constant contact with other employees who might be at risk? So do you have basically like a legitimate reason to ask them, to essentially ask them the question, you know, did you not get the vaccine because of a disability? So that's kind of what you need to be sure that you're not just asking every single employee, hey, you know, why didn't you get the vaccine? Because if that person, you know, doesn't really have a need to get the vaccine in your workplace, and you ask them that question, they might give you an answer that, you know, that will basically get you in trouble, because now you've started poking into their disabilities. Another question is, you know, if they say, no, I didn't get the vaccine, can you fire them? The answer is like possibly, potentially. But again, you're essentially in that same scenario, because you don't want to discriminate against them if they didn't get the vaccine for religious reasons, because that brings up you know, Title VII discrimination stuff. You don't want to discriminate. You don't want to fire them if the reason they didn't get the vaccine because of, you know, like disability ADA reasons. And so if you're considering having to fire someone because they didn't get the vaccine, you have to do that same kind of consideration of whether or not them not having the vaccine is posing a direct threat to other employees, is it posing a direct threat to your business? Can you can for sure, if they didn't get the vaccine, you can for sure exclude them from the work site and maybe make them work from home or something along those lines. But if your actual goal is to basically terminate them because they didn't get the vaccine, you have to make sure that it's that them having the vaccine is directly necessary, basically. So that was a lot in a short amount of time. Isaac and Marion, anything to add?
I mean, a conservative view on this is rather than require employees, just find ways to encourage employees to vaccinate. And so talking with benefits counsel and figuring out what are appropriate incentives that I can give people. Gift cards, you know, rewards, and, you know, there may be ways to fold it into health benefits, you know, advantages for being vaccinated. And so that might be a less risky approach if you're not in an industry, you know, where vaccination maybe would be essential to, you know, your business necessity based on the populations that you're serving.
Yeah, just another follow-up on the religious accommodation. So in terms of exceptions, and I think the general rule among us talking heads is that yes, employers can require this vaccine, but there are exceptions. The ADA, as Marion and Javier have alluded to, is one of those areas of the law where you have to be mindful, and religious accommodation. And what does that mean? In order for an employee to qualify for religious exception, religious accommodation, to not get the vaccine, the sort of keywords are that it needs to be a sincerely held religious belief. And we won't get into what that means because we'll be here, you know, the whole day, but it must be a religiously held religious belief. And mind you, political beliefs are not religious beliefs, okay? So with that being said, I think we're
even in this day and age.
Right. Well, with that being said, we'll move on to our next question, which I believe, Marion, you're going to be taking on this one here for us.
All right. Can employees refuse to come to work because coworkers have not been vaccinated? Certainly they can. You know, we put out a blog earlier this year, last spring actually, about all of the different areas where employers could face exposure for forcing employees to return to work and or punishing them, or, you know, having some sort of consequences against them for failing to return. And, you know, short of that risk, those risk areas, you can absolutely tell your employees, I need you in, I need you back. You know, it's time to return. We've made it safe. But here are the pitfalls. If the person has a disability that needs to be accommodated, it's difficult to say keeping you on a remote schedule is no longer feasible when we've done it, you know, for a year. So that argument is different now, you know, and it will be fact intensive. Other reasons in terms of whether there are safety risks in the workplace. And so all employers at this point should be, you know, making sure that they're fully compliant with OSHA standards and the duty of care to provide a safe and hazard-free work environment, which includes, maintaining appropriate safety measures related to COVID-19. And so if employees can point to the fact that I'm not coming back to this workplace because you're not even, exercising the appropriate duty of care to keep it safe at work, then they could very well have a valid point. To the extent that they're raising those concerns on behalf of themselves and others, that could be recognized as what's referred to as protected concerted activity under the National Labor Relations Act. We have seen in the change of administration that likely there will be much broader definitions around those areas for employees, and that the National Labor Relations Act, it doesn't just apply to employers that have unions. It applies to employers also that have non-unions with respect to protected concerted activity. So if your employees are getting together and protesting that you don't have a safe work environment, that could be protected activity. If employees are refusing to return to work for religious reasons or other reasons, you just have to be mindful. Those are the risk areas where you might need to accommodate. You might need to engage in an interactive process before requiring employees to come back. And so a good approach, a practical approach that we've seen many clients using is they're having phased return to work, and by and large on a voluntary basis. I'm back in the office, frankly, you might, as you might see. And so there are some employees that probably are ready to return, and giving folks that option to return in a phased approach for now makes sense. If you, however, require your employees to be there in order to run your business and they don't have a valid reason for refusing to come back, then you can start to think about what appropriate measures might be for replacing them.
All right. Thank you, Marian. I think you covered it all for us pretty well. I don't have anything further to add. Javier, moving on. All right, next question. What are an employee or an employer's rights when an employee has to miss work because of COVID-related childcare, school closures, things of that nature? I believe that is on your plate, Marian.
Okay. So the short answer is you need to figure out what type of leave, if any, applies. It might be that this employee, because of some illness related to COVID, that they can take paid sick time, that they can use their PTO, that they maybe are eligible for an FMLA leave, for serious health conditions. So what you do is you need to figure out what category could apply here, and then follow through with granting them their rights under that category. Now, we know under the CARES Act, the Families First Coronavirus Response Act, as I said, kind of in passing, it has expired. If you are one of the employers who wants to continue to take advantage of those tax benefits through September, then continuing to provide employees leave for things that are covered, such as childcare and school closures, would enable you to take advantage of those tax credits. As of this morning, when I looked, the Department of Labor hasn't updated its guidance on this issue. And I think the IRS is also going to provide employers with some additional FAQs on how to handle the tax credits going forward. Those are the two resources that I'm keeping my eye on. So if you're interested in continuing to avail yourself of those benefits, which cover things like childcare, school closings, there are 3 new ones. It also now covers time off for testing for COVID, time off for a family member getting vaccinated for COVID, and recovering from an injury related to COVID. So those are now 3 additional categories that apply. But the DOL website and the IRS website, as well as probably any of our firm websites, we're continuing to put alerts out on these topics, would be good resources to check.
And I know we're running short on time, but I do want to make sort of a practice pointer, and I'll put this as a question because I'm not sure the definitive, dispositive answer. But if an employer decides that they need to get rid of an employee and offer as part of a severance some sort of payment, I believe, and I thought I read somewhere, that if I'm terminated an employee, I can maybe use some of the funds that would qualify under the CARES Act towards that settlement, and would it still be tax deductible? Do you know?
I don't have the answer on that specifically, but I think the IRS website would certainly help shed light
Okay.
on that.
Right.
I mean, what we do know is from the recently passed American Rescue Plan Act, which is what authorized the extension of the CARES Act leaves, that under that law, it definitely broadened the types of categories that can be included in for the tax deduction. And so, so what we're waiting on now is just for additional clarity from the IRS and DOL on how that will work.
Awesome.
Yeah.
Thank you, Marion. All right, let's try to get through these a little quickly, and then maybe we can squeeze in a question or two.
right.
Are employers required to offer telecommuting or remote work options, Javier?
Thanks, everyone. I'll try to be very, very quick. So just from the perspective of the ADA, I would say if an employee is currently has COVID, yes, absolutely. That's considered a disability right now during the pandemic. Please offer them, telework, especially so that way they don't get anyone infected. If someone doesn't have COVID and doesn't have any, and is just generally, I'm afraid of getting COVID, at least under the ADA, that I haven't seen any guidance that is a sufficient reason to require giving them work from home. I mean, obviously the employer can choose to, but you're not required to, at least. And then, but the middle ground scenario is, what if someone has an underlying, even if someone doesn't have COVID, but they have an underlying condition that makes them more susceptible to COVID, diabetes, hypertension, et cetera, and they're asking to work from home or continue working from home. That's the kind of the gray area. There's one case that I saw where an employee had a moderate asthma, which pre-COVID wouldn't have been considered a disability under the ADA. But given the interplay between asthma and COVID, that they were found to be basically sufficiently at risk of coming down with COVID that the employer had to give them a reasonable combination in terms of working from home. So I would say that's kind of where that's the middle ground situations. Someone that doesn't have COVID but does have some sort of underlying conditions that you're aware of, they've made you aware of. And so if that does happen, I would, give it a lot of consideration, most likely, contact counsel so that way you don't end up in a landmine. So yeah, that's my answer. I don't know, Marion and Isaac, do you guys have anything different?
I think that covers it. Let's get to our last two questions really quick. Javi, I think this one is a pretty short one. My employees are concerned that skipped one, I'm sorry. Can employers require temperature checks, Javier?
Yes, absolutely. Absolutely. Just a couple things to keep in mind. Temperature checks aren't a perfect, test. People have high temperatures for non-COVID reasons. We have people who have COVID and are asymptomatic, and you're not going to catch them. So at least keep that in mind. But you absolutely are allowed to do temperature checks. Just some best practices for them. Make sure that your process is consistent and accurate and reliable. Have one designated person who's the temperature check person. Ideally, if you can, have the temperature checks be outside of the building before people go in. Best practices might even be have like a little tent, so that if you have a line of people waiting to go in, you have a private, screening tent, so that way the other people don't see what the results are. So that way you keep the results confidential. Keep the results confidential. Make sure that the person who's administering the test they don't have to be a trained medical person or personnel, but at least make sure they're trained on how to do this. Make sure they're fully geared up with PPE, with gloves, face shield, mask. I think that was, and and make sure to keep the results confidential. But yeah, you're absolutely allowed to do the temperature checks.
And alternatively, if you want to avoid having to have one person designated with full PPE doing these tests, another option is just to have employees complete a wellness certification before they come on site. And, employers have gotten good about just putting them on an app or making them digital. So you open it up, you click through, and it's not just, I attest that I checked my temperature within the last 2 hours and I'm not above, 100 point whatever, but also I haven't been around anybody. I haven't tested. I'm not waiting for test results. I don't have any of these other symptoms. And so you're really capturing a lot of information without because a temperature check is a medical process. And to the extent that you record those temperatures, you've got to keep those, for an inordinate number of years, or, it's a violation. So an alternative approach is just have employees complete a wellness certification about all of the, appropriate symptoms, and ensure that in fact, they're not at risk. And we have sample wellness checks. They're also available online. You just want to make sure you're not asking questions that are inappropriate.
All right, question, 30 seconds or less. My employees are concerned that customers come in refusing to wear masks. What do I do? Marion.
Sure. So notwithstanding the governor's order a few weeks ago that counties can't pass mask mandates, employers are still subject to all of the laws and regulation around providing a safe and hazard-free workplace. And so one way to prove that you're doing that is complying with your CDC guidance, at the local level, so that if you're visited by ADOSH or Cal OSHA, right, and they have increased their enforcement, particularly in California, because they've had to. But if you're visited by one of those agencies, that you can demonstrate that you're meeting the guidance at the federal and local level. And one way to continue to do that is through mandating masks in the workplace. The CDC has given us good guidance that provides when masks aren't necessarily required going forward. But the problem is that it distinguishes between vaccinated and unvaccinated people. And if you're operating a business that provides services to the public, there's no way to know who's vaccinated and unvaccinated. And so you can't take the risk of exposing your employees to individuals who may or may not meet the CDC requirements to allow individuals to be around each other indoors unmasked. So if you want to continue to have a mandate for mask wearing in your place of business, you're absolutely in the right to continue to do that until further guidance. If somebody has a disability, if a child's under 2 years old, or if there's some other exception for why somebody can't wear a mask, you might have to, allow in those cases for some accommodations. But short of that, you're entitled to continue to require masks, and it's a good, easy way to provide protections in the workplace. One thing that we've learned in this whole pandemic is that the guidance is changing. Every day, we are seeing developments. And so this is really an area where employers, businesses need to just try to stay abreast of what they're learning and continue to make changes in the workplace that best protect employees.
Yeah, so that's a good segue into our last and closing slide. You've heard a lot of acronyms throughout the day today in terms of the laws and the different agencies. This last slide provides you with a list of 4 state and federal agencies whose websites you're going to want to check on a regular basis. EEOC, that's the Equal Employment Opportunity Commission, oversees anti-discrimination laws, including the ADA, provides a lot of very helpful guidance for employees and employers alike. Similarly, for the Department of Labor, OSHA is your health and safety agency, and the Industrial Commission of Arizona does a lot of the same stuff. I apologize for the A missing on Arizona. Stay on top of it, check websites on a regular basis. Small and large employers need to have somebody designated to be monitoring these websites on a regular basis or making regular contact with your outside counsel for any updates. With that being said, I think we're going to go ahead and close it up. Thank you, everyone, for participating or looking at this presentation at some point down the road. Thank you to our presenters, Marion and Javier. Thank you for your time. Time is precious, especially in these days. So thank you both for sharing your expertise with us today. Elizabeth, hand it over to you. Closing thoughts or final questions?
Wow, this was really great. Thank you so much for your time today. And we'll make sure to pass along your contact information for everyone who's in attendance, along with the recording of today's session in case you'd like to share through your networks as well. But on behalf of the Chamber, we'd like to thank you, Isaac, Javier, and Marianne, for your time. We also want to thank Los Abogados for connecting us together and, being able to bring this great presentation. We look forward to partnering with you all again sometime in the near future. Great information and very timely, by the way. Wish you all the best, and thank you so much for your time today.
All right, thank you.
Bye, everyone.
You're welcome.